Hey, this is Ryan Witt, defense attorney here in Western Washington. We get a subset of calls that I will classify as limitations of actions or statute of limitations calls. And they'll go something like this. Caller will ring us up and say, hey, I had a little run-in with the police, they were involved, but that contact was 3 months ago, 6 months ago maybe. Or other callers will be like, this went down, I got a DUI stop, I haven't heard anything about it. It's been a year, it's been 18 months. And I'm just calling you to make sure I'm all good. I'm sure it's water under the bridge and never got anything in the mail, but I just thought I'd call and make sure. Well, if you are in that situation, this is a video for you, so stick around. Okay, so that scenario I was describing a moment ago is happening all the time, and it seems to be happening more frequently now in the last few years. I don't know if it's something of a backlog from COVID or prosecutors' offices being understaffed or, well, I know the crime lab has a big role in this, just things go in there and it's kind of a black hole where evidence never comes out of. But there is a protection for people that are accused of crimes. It's called statute of limitations or limitation of actions. It is enumerated in the RCWs. And what that means is there is a hard wall. There is a limit to how far out they can go. And based on the RCWs, it can be, well, for the most heinous of crimes like murder, it's forever. Then there's 20 years and 10 years, 6 years, 5 years, 3 years, 2 years, and 1 year. And all those different years and timelines are basically, it has to do with the seriousness level of the crime. So the ones we're really going to deal with in this short video are the gross misdemeanors and misdemeanors. Those are the charges that are brought in the district courts and the municipal courts of our states. So a common gross misdemeanor charge would be, DUI or physical control, could be reckless driving, assault, harassment, driving suspended, second degree. Those are the really common charges that we get, and that is a 2-year statute of limitations. The less serious crimes that again happen in municipal and district courts are things like, driving suspended third degree or trespassing in the second degree or disorderly conduct. That is a 1-year statute of limitation, meaning if, from the offense date to the date the crime is charged, if it's beyond 1 year, you can get the case basically tossed for a limitation of actions violation. Now there's a caveat to that, and the exception to that is you have to be usually and publicly a resident of the state. So for example, let's just say a crime of DUI, 2-year statute of limitations. If you're in the state for 1 year, but then you move out of the state and you stay gone for, a year and change, however long, and the case gets charged, maybe let's say even at the 3-year mark, they could still could file the charges and your statute of limitations defense would fall flat because you've really only logged a year where you are publicly a resident of the state. Hopefully this video was informative to you. We would sure appreciate it. It helps us get more content out if you like the video and subscribe to our channel. If you've got a question based on it, go ahead and drop the question in the comments and we'll either do our best to reply to your question or maybe we'll just do a whole new video answering your questions. So please like and subscribe and thank you for watching.